Good afternoon. Welcome you all to the 20th Digital Dialogue organized by the Lawyers and Jurists Foundations, the Business Standard and London College of Legal Studies, LCLS. Today we have amidst us the chief guest, special guest, keynote speaker and esteemed panelist. Initially would start addressing the chief guest, Honorable Justice M Imman Ali, sir, Honorable Judge of Appellate Division, Supreme Court of Bangladesh. On second, we have special guest, Honorable Justice M Khurshid Alam Sarkar, sir, Honorable Judge of High Court Division, Supreme Court of Bangladesh. Thirdly, we have guest panelist, Mr. Faruque Hassan, sir, President of Bangladesh Garments Manufacturers and Exporters Association. Due to some technical reason, he couldn't be on time, but he will be here sooner. On fourth, we have guest panelist is Mr. Rizwan Rahman, sir, President of Dhaka Chamber of Commerce and Industry, DCCI. Fifth, we have guest panelist, Mr. Muhammad Arfan Ali, sir, President and Managing Director of Bank Asia. Next guest we have is the keynote speaker of today's event, Dr. Khaled Hamid Chowdhury, sir, Barrister at Law, Fellow of the Chartered Institute of Arbitrators, Advocate, Appellate Division, Supreme Court of Bangladesh, and Head of Laws of the Institute, London College of Legal Studies, South. And last but not the least, the final guest panelist we have is Mr. A.M. Masoom, Barrister at Law, Fellow of the Chartered Institute of Arbitrators, Advocate, Appellate Division, Supreme Court of Bangladesh. I welcome you all to the 20th Digital Dialogue, today's event. Today, I'm your session in charge, Khandakar Asma Hamid, Advocate, Supreme Court of Bangladesh. Our today's discussion topic is implementing alternative dispute resolution in Bangladesh, prospects and challenges. Basically, the topic itself is pretty much vast and demanding. Alternative dispute resolution has been developed as a mechanism of law for the speedy disposal of disputes. For the time being, alternative dispute resolution has become a popular device in countries like Bangladesh as the courts here are overburdened with the cases. As law itself is a changing process, we need more efficient devices to change the current structure of our legal justice system. Today's discussion will aim to propose to develop the new concept, theories, and ideas about how alternative dispute resolution can be implemented in most challenging ways in Bangladesh perspectives. Alongside, an ADR process is very popular in Bangladesh as both the plaintiff and the defendant get their benefits from this process. And as a matter of fact, the ADR reduces the workload of a formal judicial system in Bangladesh to a greater extent. However, alternative dispute resolution has certain disadvantages too, and we need to implement ADR in a way that it cannot harm our justice system. Thus, finding the proper way to implement alternative dispute resolution will be the essence of today's event's discussion so that we can use these ideas and proposals by our chief guest, special guest, and the guest panelists effectively. Today's discussion will help to open with the topic in its entire means. So without any further delay, let's commence from our today's event keynote speaker, Dr. Khaled Hamid Chowdhury, sir, what he has to say about alternative dispute resolution in its entire means. Welcome, sir, for being part of today's event.
Thank you very much for allowing me to present this keynote in this occasion, the Digital Dialogue 20. My humble respect for the chief guest of the occasion and special guest, and of course, my fellow co-panelists. The ongoing global pandemic caused by the COVID-19 has caused a worldwide economic meltdown and has had a devastating social impact. As a consequence of the deadly pandemic, every corner of the globe came to a complete stalemate. With the second wave, we are engulfed with more uncertainties. Global economy, mobility and communication, education, and social normalcy have been diluted through restrictive measures taken by governments in order to curb the virus. Access to justice was significantly hindered as courts and tribunals were compelled to shut down. In Bangladesh, in March 2020, among other institutions and sectors, the courts also closed their doors, which in turn meant that the pending cases had been adjourned while incoming justice seekers have had no access to initiate processes for judicial intervention for some time. Now, responding to the prevailing crisis, initiatives were undertaken to digitalize court proceedings, although to a limited extent and gradually since passing the ordinance in May last year. Virtual courts have been continuing to hold judicial proceedings remotely and very efficiently. Along with the formal judicial business, the need for resorting to alternate online dispute resolutions, which I would call ODR, was also acknowledged and recognized in these pressing times. Hopefully, we will have a complete infrastructural and logistic-based virtual court management system in not too near future, which I think is the need of the time. The pandemic has been a blessing in disguise for that matter, that it highlights the important role played by the ADR and ODR mechanisms alongside the traditional justice system. Despite the ongoing efforts, more steps for research need to be carried out by the relevant stakeholders in this sector. Now, why ADR is needed? Presently, the number of cases pending in the courts would be over 4 million and counting. Added to that, for a country with population of 170 plus million, the number of judges is highly inadequate to say the least. Also, our Supreme Court based in Dhaka, without any of its benches sitting elsewhere, access to justice is becoming increasingly narrower. The aftermath is that access to justice being obstructed, which is our constitutional right of the citizen, since our constitution mentions that justice needs to be ensured at all stages of judicial dispensation, amongst other things with equal right to life, personal liberty, equality before the law, and entitlement of equal protection of law and the right to be treated in accordance with law. Therefore, there is no alternative other than promoting the effective use of ADR and ODR where possible and necessary, as dispute settlements through litigation remains a challenging and cumbersome process with the country's overburdened judiciary. Now, the background to ADR very briefly, the concept is not new at all. Since our independence, some efforts could be seen to have been made to make it a part of the judicial dispensation culture. ADR typically would include early neutral evaluation, negotiation, conciliation, mediation, expert determination, adjudication, and arbitration. In 1985, ADR was included in the Family Court Ordinance keeping mediation provisions. In the year 2000, with Mr. Justice late lamented Mustafa Kamal Sir at the helm, pilot courts were established exclusively for disposing family cases through mediation that received tremendous success. This encouraged the amendment of the Code of Civil Procedure incorporating mediation provisions in 2003 via Section 89. Problems and shortcomings, of course, are there. Unfortunately, response from the lawyers, the litigants, and other stakeholders were slow. And the downward trend has remained until perhaps the pandemic realization. Additionally, there is prevailing adversarial mindset and widespread pro-litigation culture. I would say poor knowledge of ADR of all parties concerned, lack of encouragement from the advocates, tendency to harass the other party through a court battle, lack of publicity, lack of training to attain expertise in ADR are also among the reasons highlighted for the scarcity of its success. Now, hopefully, there are now some very encouraging signs of improvement and increased level of awareness. Having said all this, we have ADR included in different statutes, which can be explained in three ways. There is extrajudicial or community-based initiatives, ADR in quasi-formal systems, and finally, ADR in the formal legal system. Among the numerous statutes where ADR provisions are incorporated, we have the Income Tax, VAT, Customs Acts, the Muslim Family Law Ordinance, then the Legal Aid Rules and the Acts, the Arbitration Act, the Money Loan Recovery Act, we have the Village Courts Act, the Labor Act, also Real Estate Management Act, Public Procurement Rules. Now, it's not possible for us to go through all these acts and sections. However, ADR under CPC, I would say, is one of the most prominent provisions which is included in our law. It defines, for example, mediation as a flexible, informal, non-binding process which is confidential, non-adversarial, and consensual dispute resolution process in which the mediator shall facilitate compromise of disputes in the suit between the parties. As per Section 89, the court may adjourn the hearing, pass an order to mediate in order to settle the dispute, or refer it to pleaders or to a mediator from the panel for undertaking efforts for settlement through mediation. The word may was replaced by shall in 2012. However, the aforesaid panel of mediators may consist of qualified mediators prepared by the district judge in consultation with the president of the District Bar Association under the relevant provisions of CPC, and very significantly, no appeal or revision shall lie against any order or decree passed by the court in pursuance of the settlement through mediation under the section, which will lower the pressure on the courts. So, ADR has not been widely introduced in criminal justice system. However, even there is a quasi-formal ADR for less serious crime as to compounding offenses under Section 345 of the CRPC. Now, other than that, Village Courts Act and I said the Labor Act are all functioning in their respective perspective. Now, I would shed a few lights on the overall mediation sector scenario in Bangladesh. Mediation, as I've said, is a peacemaking method of dispute resolution. It is flexible, wholly party controlled. The solution comes from the parties themselves, and when both parties mutually agree, a mediated settlement agreement can be drafted that is enforceable and challenged on very narrow grounds. So these features of mediation has made it very popular across the globe, especially for small claim dispute settlements, but unlike Bangladesh, where we have been quite slow to pick this up. So as I've said, that the lack of awareness, ineffective use of Section 89, absence of sanctions for unreasonably refusing ADR, I think are the key causes. This is where we all believe that the role of training and spreading awareness about mediation becomes so important. In this context, we must say that the recent Supreme Court circular dating 21st March is like the light at the end of the tunnel and could not have come at a better time. This circular by our Supreme Court on the enforcement of the mandatory mediation provisions in the CPC and other statutes is much commendable. Much credit must be given for the efforts undertaken by the Committee on Judicial Reforms for promoting the importance of mediation in the dispensation of justice. The highlight of the circular is that if there are any problems with the implementation, or if any judge even is reluctant to follow the guidelines as stated, the concerned authority will be required to notify the Supreme Court of the same. Our Honorable Supreme Court, it has reiterated in that circular the need to comply with the relevant ADR provisions in the various statutes, expressing its concerns for persistent failure to do so till late. Some recommendations, I believe that the Bangladesh may consider implementing its own mediation regime like the Mediation Act, as has been done in Singapore. We can be proactive in that manner. In that way, we can have domestic mediation, international commercial mediation. At the same time, I would urge that we should also consider signing and ratifying the Singapore Convention on Mediation entered in 2019, where cross-border mediated settlements are being enforced through the member states. This did wonder for arbitration via New York Convention in 1958. So this is something I think it's the order of the day. I believe that our lawmakers and stakeholders should also consider changing relevant laws, amending the laws, and particularly the proper terminology for the role played by the dispute management experts must be explained. For example, the Shalish Tribunal in Muslim Family Law Ordinance is confusing. The Power of Attorney Act 2012, along with the Real Estate Management Act 2010, has conflicting ADR provisions, which has led to a number of unnecessary prolonged disputes. So having said that, I believe that we are developing by leaps and bounds. We have many leading projects like the construction of the Padma Bridge, metro rail, power plants, and for all these projects, international transactions and trades are growing immensely in Bangladesh. So ratification of international conventions, making this more popular, would go a long way to put us on the map in the proper perspective. I would also urge that ADR clause be drafted in every commercial and relevant contracts. When the pandemic hit, among other affected sectors, the setback faced by our RMG sector was of paramount significance. Major brands and retailers refused payment to factories worldwide for about 40 billion worth of completed goods. Data from the BGMEA had showed at one stage we had more than 1,150 factories with order cancellations since the virus outbreak. For the greater interest of our economy, the interest of both the garment sector and the banking industry must be protected. Mandatory, well-structured, negotiated provisions of ADR clauses into all commercial contracts can help resolve business disputes expeditiously, which is the need of the hour. And obviously, this would in turn lessen much burden on the courts. More trainings and workshops collaborating legal professionals and entrepreneurs should be conducted so that awareness can be built at a pre-contract negotiation stage and adequate protection can be taken. As an educationist, I would also urge teaching and promoting ADR at the university level more intensively. This would also mean that there would be an increased skilled mediators and conciliators, since the norm is that people get familiarized with ADR at a later point. This mindset would change, must change, and the young professionals must advise their client that court should be the last resort, not the first resort. And I would say that pre-litigation mediation should be made mandatory for recovering the non-performing loans. Why go for mediation after the case has been filed and not before? Therefore, aggressive training, more publicity, and more awareness creating events across the country should be the order of the day. A brief few points about arbitration, which is perhaps the most popular method of ADR, by the Arbitration Act 2001, which is largely based on the ancestral model law, having also taken its roots from the English and Indian Arbitration Acts. Now, despite adhering to the essential doctrine of modernization, Bangladesh still has a long way to go, and there are lots of challenges in the way that needs attention. For example, when it comes to interim relief, one of the contentious issues that has surfaced on the applicability and scope of the Arbitration Act 2001 to a foreign-seated arbitration when the arbitration is taking place outside Bangladesh. Until recently, our high courts the different benches of our high court division reached conflicting conclusions while interpreting Section 3, while one line of cases saying that this should not be applicable to foreign state arbitration, whereas opposing line of cases saying, no, we can apply. Now, having said that, recently in a case where the case called the Project Builders, it stated, nowhere the problem as stark as in the case of Bangladesh Courts Authority to rule on interim measures of protection when the arbitration is seated abroad. So His Lordship Justice Rifat Ahmed addressed this point in the Project Builders case. However, in a number of cases, starting with the Southern Solar Power judgment, with the author judge, respected Justice Sarkar is here with us today, our High Court division has opted for a more consistent pro-arbitration purposive approach, taking the view that in none of the previous cases, the applicability of Section 7A was directly in issue, and a plain reading of Section 7A would show that Section 3 did not oust our jurisdiction of the courts and the provision dealing with the scope and applicability of the Act. Hence, our courts can come to the aid of an arbitration by granting interim relief, which is foreign seated, which is much welcome, but perhaps there would be a more certainty if an approval comes from our highest court or the lawmakers as such. Now, to wrap up, I must say that arbitration has become a costly process. There is no time-binding issue there. Often parties are complaining of complexity, delay. Therefore, more clarity, more training is needed. Perhaps we can amend our act looking at the Indian acts, like having a time frame for the fast track arbitration, and also depending on the financial claim, and putting it in a time frame which would actually help all the stakeholders as relevant. And at the same time, I think institutional arbitration should be promoted. We have BIAC and few other institutes trying their best to make it popular. However, we all have a long way to go because the parties are yet not very comfortable with the institutional rules and norms. Therefore, more awareness would be needed. Personally, I have also seen sometimes writs are preferred over arbitration under Article 102 of our Constitution, which makes the matter complicated. Therefore, parties should not be allowed to avoid ADR clauses too easily and seek resort under the provision of fundamental rights, although it is our right. However, why not seek the adequate alternate remedy in the first place before disturbing our highest court, which is already overburdened with so many cases? So hopefully, arbitration being a very complicated matter, there must be more training, more sort of rapport and sort of more collaborative discussions like this to make it more popular. We might even finally think of setting up an arbitration council, as I've said, taking examples from other countries, and as I said, promoting more institutional rules and norms along with the fast track figures. Final point, we still have a long way to go when it comes to development in the field of ADR in Bangladesh. Efforts should continue in all sectors by all the relevant stakeholders. And I must comment the recent Supreme Court circular, which has added a lot of momentum to that end. And hopefully we will see positive effects of the same in the near future. Thank you very much for your time and attention.
Thank you so much, sir, for enlightening us the knowledge of alternative dispute resolution, discussing about it in a wide manner. Now we move to our next guest panelist, Barrister A.M. Masoom, sir. Sir, pursuing and holding on to Dr. Khaled Hamid Chowdhury sir's speech, can you share how can reforms be made for covering the regulatory loopholes that makes the investment sector graph both domestically and internationally move upward from downward? Local investments and foreign investments dutoi kome giyeche. So what initiatives can be taken to improve the investment sectors? Please make an economic analysis on these aspects.
Thank you very much, Asma, and with Mr. Chowdhury for the excellent presentations and today's distinguished guests and the esteemed panels. To all, Assalamu alaikum. Asma, the question you have posed, it's two directions. One is the international part and the domestic part. So the international investment, if we just look into within examples, like a data of 2019, if you see FI foreign direct investment in 19 in Bangladesh, it was $1.6 billion. But competitive countries, if you consider with Vietnam, which was $16 billion, at the same time, if you go with the Indonesia, it was around $23.56 billion. So the result is what I think is not satisfactory. But whenever a foreign investment comes to any state, the foreign investors generally look into few factors. One of the most important factors is that whether the state political and the policy consistency is there or not. The second stage, that when they invest in a host country anywhere, they look into that there is the protection of their investment. The investment they're going to do, will they get it back? And for that, they check into whether there is an investment treaty or the bilateral or multilateral or any free trade agreements with that states. And of that treaty, there would be with the ADR clauses, the alternative dispute resolutions, how that state respects it. And then the last stage, they come up with the other agencies ranking. For example, the World Bank report, if you look into 2019, as for the COVID 2020, they haven't done the report published. But the 2019 data, that the ease of doing business, if you check, that you see that our ranking is 168 out of 190 countries, whereas the 10 indexes, one of the indexes is the enforcement of contract. And this, there is in Bangladesh, like it takes in a district court 4 years to enforce that contract, but the cost of this is a 66% of the contract value. At the same time, if it's a developed country, it takes 1.5 years to enforce that contract, but the cost is 20 to 20% of the contract price. And that is the reason Bangladesh, in enforcing contract ranking, it becomes like 189 out of 190 countries. Again, if you come to other one, that's the World Economic Reform, that's the Global Competitive Index, which is carried out in 2019, not 2020, not done because of the COVID. But over here, it's a 12 pillars to consider, and out of 12, 10 is declining, and Bangladesh ranking is 105 out of 141 countries. But there is a one point is called institution, and there is a score of Bangladesh is 109, only because of the regulatory framework. It means the ADR and with the functions of the litigations. And the last, if you see the Economic Freedom Index 2021, which carried out, we have a score 56.5 out of 100. And that's, there are 4 pillars they considered into it. One is rule of law, governing government size, regulatory efficiency, and the open market. The problem with us is the rule of law and the regulatory efficiency. Again, it comes to the ADR. But over here, they assess the countries with the, like the most good one with the free, and the most free, and the mostly unfree economic freedom. And those are the countries below 60, and this Bangladesh, because it's got 56.5. So it's a mostly unfree economic, the economic freedom enjoys. So what it happens, whenever a foreign country wants to invest in Bangladesh, they actually assess this criteria and go through with this. And that's the reason our inflow of FDI, it's like a 1.6 billion, as I said to you. But if you look into 4 years data of the BIDA, it comes around 11 billion, which is still very poor. Now, if you come to the local investment or the domestic investment, again, you look into the private credit growth, which we have like 2 years before even, it's around 17, 16 or 18%, but it's now came roughly around 8%. Again, the private investment growth, which was 23% stagnant before, but it's now around 12% on an average. So the private investment also getting less, though we are projecting our GB will be 7.4, before it was around 8.2 or above 8. But the thing is that in our economy, you will see one thing, it's a bank-driven economy. As it's a bank-driven economy, bank generally do all the investments to create the industry. Like the developed country, what you will see is the mostly 75 to 80% investments generally comes from the capital market, unlike Bangladesh. But in Bangladesh is the bank driven, and that's why our deposit, one of the most, a crucial part is the non-performing loan, because when banks invest, banks get the revenue, and then bank reinvest in the domestic market. But when it's a non-performing loan more, like if it's a before COVID, you consider it's around 9.3% the government rate. But if you look into the IMF, it was around 23%. But if you look into the Bangladesh Bank's stressed asset definition, there is a 33%. So the non-performing loan, it's more, and that is the reason bank is not capable enough to invest more in domestic sector. So if you consider that bank is going to recollect, or the tools banks generally use to collect the non-performing loan is the two statutes we have so far. One is the Negotiable Instruments Act, another is the Auto in Adalat Ain. So in Negotiable Instruments Act, the stand at the moment the cases pending, if you look into the lower courts, we have around 6.17 lakh cases pending in lower courts, and in High Court, it around 1.5 lakh cases, only check dishonor cases. And till December, we have Orthoin Adalat cases, around 74,000 cases in lower courts, and 22,000 cases in the high courts, and we have the 1.25 lakh crore taka in total, which is stuck in these cases. But this is the orthorin and the negotiable instrument cases. But if you look into the overall scenario, what is the data we have? Like in lower court cases, we have a 31 lakh cases pending, whereas only 3,000 judges. We have in High Court around 5 lakh cases. We have around 95 judges. Around Appellate Division 21,000 cases above, whereas only 6 judges are there. So the backlog cases is huge, but it's not only in Bangladesh. We can have the example like Brazil has a 80 million cases pending backlog. We have a example like India has a 30 million cases pending, but there is a way it can be resolved. Like eBay has given a proper example, like they have a 60 million cases every year, the disputes between the trades, all the traders, and how they resolve it. They don't go to with the conventional court systems. They do it through the ADR and the ODR. So the same way, how we can resolve it, I think the only way we can resolve it or to make it quick recovery, that is the first thing we need to look into ADR, it's meant the arbitration, mediation, and then we need to look into the litigation, how we can make fruitful. But first of all, if we come to the litigation part, there are some statutes which should be amended, and I think the government has taken the initiative to amend it. For example, Foreign Exchange Regulation Act 1947, we have a Foreign Private Investment and Protection Promotion Act 1980. We have the Income Tax Ordinance 1984. We have the Customs Act 1969, Orthoin Adalat in 2003, Financial Institution Act 1993, among Bank Companies Act 1991. Above all is the Arbitration Act 2001. But most of the statute, government has taken initiative to amend it, but I think the arbitration should be taken very quickly. Above all, there are other things we need to improve, I think, as Mr. Chowdhury has already mentioned it, like in arbitrations, the litigation cases, if you look into Singapore here, in Singapore 2015, what they did, they have a separate commercial court for the Singapore International Commercial Court. But same way, we can have it for the to enforce the contract, we can have a separate commercial courts. What I think the government should take into consideration. In relation to mediation, as Mr. Chowdhury mentioned, that there is a amendment in CPC in 2012 by 89A, but still we don't have the rules for it. But I think this rule should be prepared as early as possible. And another thing, we should be signatory in the UN Mediation Convention, as popularly known Singapore Conventions. That's what we're not signatory yet, but we must have to be signatory there. As well as there are in Arbitration Act, few changes. I think it's mandatory we need to do it, as India did it in 2015, their Arbitration Act 1996. So there is a section 2B in our Arbitration Act, the definition of court. India did it on the High Court, and the as Mr. Chowdhury mentioned about the section 3, which is any arbitration takes in Bangladesh, it means the place of arbitrations will have to be in Bangladesh to apply this act, exempt 45, 46, and 47. I think that should include section 7A, which section 10 of the arbitration. Again, if you see the 7A incorporated in our country is 2004, but in India 2015, they have already amended it. Irrespective of the place, they can seek for the interim remedies. At the same time, if you get on with the spirit of ancestral model law, where is Article 17 is given the irrespective of the place of arbitration, you can seek the interim remedy. Again, section 42 to 48, where is the setting aside of arbitral award? I think it should be irrespective of domestic or the international. It should come to High Court. And there is a section 12 for the appointment of arbitrators, and section 42. I think there is a time limit, 60 days. It should be honored and it should be followed very strictly. Again, we don't have a proper institution like LCIA, ICC, SIAC, HKISA. I think the government should patronize, or the government should promote institution like this in Bangladesh. At the same time, like the Ortho in Adalat line, there is a section 22 to 25, which is a ADR. Even Law Commission suggested in 2015 there should be a rule, but that rule didn't prepare yet. I think the Financial Institution Division now taken initiative that they are going to amend the Ortho in Adalat in 2003, and they put the ADR rules there. And there is another point. I think the BIAC has proposed to central bank to recover the NPL by using ADR, and there is a draft guideline given in 2018, and based on that, Bangladesh Bank also formed a committee, but no progress there. Whereas I think their suggestion was that up to 25 crore Dhaka dispute that should be dealt by the arbitration or ADR, can be mediation, and that is whether it is pending in writ jurisdiction or the lower courts through the Bangladesh Bank's guideline and the circular. But I think there should be a proper thought into it, and then this process can be started. Another thing we need to mention about the statutory arbitration, we have a statute. We have the institutional arbitration, the institution BARC, and that's in 2003 Act, BARC Act 2003, Section 40, and all the the energy-related disputes arbitration takes place in BARC, but that rules generally BARC rules 2014, and there are so many arbitration has already taken place by these rules, but unfortunately, in 2020, they came up with a thing saying that the 2014 rules it's invalid because it's not weighted by the legislative body. So it means so many arbitration has taken place, award has given, but these arbitration, all of the award will be challenged in the writ jurisdictions. I think I have some experience there as well. And there is another thing, as Mr. Chowdhury mentioned, about the writ jurisdictions. There are the contractual disputes, and it's mentioned even the arbitration clause, but still the writ becomes maintainable. Not only from the High Court, we have found the judgment from the Appellate Division as well. I think there should be a very strict bar that it should be decided, or it should be the finality will be the tribunal, not to any other court. Thank you very much, Asma.
Thank you so much for the way you sublimed the fact associated with the country's investment sectors, economic, and the implementation method of ADR. Thank you so much. Now let's move to our next guest panelist, Mr. Rizwan Rahman, sir. Thank you for joining us in today's discussion, sir. As we know that DCCI partnered with Bangladesh International Arbitration Center, BIAC, resolving any disputes arising out of trade, commerce, and investment made in Bangladesh or by Bangladeshi individuals. How is this partnership benefiting DCCI at large scale? And sticking to this point, we want to also know that how effective is alternative dispute resolution in letter of credit related to international trade disputes, and how helpful the mechanism is.
Thank you. Thank you for having me here. Honorable Lordships, fellow panelists, Assalamu alaikum and Ramzan Mubarak. I'm just going to move straight to your second question first. You asked about the ADR and LCs. We have Mr. Arfan Ali as a speaker here, but I'm just going to be very brief about it. I think that ADR is beneficial for importers and exporters in terms of cash flow and cost of settling trade transactions. So Dhaka Chamber is a large voice of over 4,000 to 5,000 SMEs. So we have a huge amount of importers as well as exporters. And on the other hand, we also know that the implementation of ADR, it actually reduces the commercial risk, payment risk of exporters, and the much talked about export competitiveness, which we had from our keynote and the fellow speaker today. And also, I think that non-payment of LC and added LC charges that actually affect the manufacturers, importers, as well as exporters and relevant stakeholders and the entire value chain of the nation. So institutional ADR, I think, plays an important role to increase the confidence level of exporters and importers and bank in the entire process by offering faster resolutions to payment delay dispute and payment default dispute and contractual obligation breaches. And I also want to highlight the fact that, as for BIAC, aside from the MOU, Dhaka Chamber is also a sponsor of the Bangladesh International Arbitration Center. I spoke to the BIAC office yesterday to present something to you and to the lordships here who are present, our chief guest and our special guest, that BIAC so far has completed 314 hearings. And interestingly, a further 107 hybrid hearings during the pandemic regime. And I think we have this rule of any settlements of less than 5 crores needs to be settled within 90 days. And anything above 5 crores, a maximum of 388 days in settlement. And so just to highlight where I heard in the keynote that Dr. Khaled just mentioned, the workload of the judicial system. So I am very sure that these 314 hearings and as well as these 107 virtual hearings has definitely reduced the workload of the justices, honorable justices. And of course, time sometimes is money. I'm going to be a bit abrupt now, if you allow me, just to bring to your knowledge, this arbitration is a chicken and egg situation for the lawyers and the clients. Clients have a backward mindset. Clients feel arbitration is very expensive. Lawyers charge a lot of money. Why? And then there's another group of lawyers, I must say, who love to haggle their clients for 10 years, 20 years, and so on. It's easier to get those fees in over 20 years' time. I'm sorry, but this is very true because I'm a businessman. I have 2 more corporate fellows here, and we all know that's the case. And so there's 2 groups of lawyers. One is pro-arbitration, one is anti-arbitration. But I believe arbitration is not, as a businessman, and of course we have the spokesperson from the largest association in the country, the president of BGMEA here, who will definitely support me when I say that arbitration is the cheapest method. It just makes you spend that same amount of money that you would spend in the next 20 years, you're going to spend it in the next 20 minutes and get it over with. I don't exactly see what the problem there is. We can settle the case and move on. Reduce the workload from the justice system. Commercial dispute resolutions, I humbly request that the Ministry of Law should consider to make it mandatory that they should come through arbitration. Look at Vietnam. They have commercial justice resolution assigned to ADRs, and they have automation of case assignments. I'm very new to this arbitration system, but what I can say is I've been working very much with the BIDA in the last quarter, very closely. One of the main reasons of the ease of doing business index and the GCI index that fellow panelist has mentioned, the global competitiveness index, is primarily because of the speed of the justice division in moving with the cases, and also the insolvency issue that is much talked about. We have spoken to the private industry advisor, we have spoken to the BIDA chairman. Everybody's, and also the law secretary. We have also sat with the law secretary as well. And we all decided unilaterally that arbitration needs to be made aware among the businessmen. Now, being made aware among the businessmen, that is where DCCI, MCCI, or BGMEA, and all these associations, they come in together to arise the awareness and also try to explain the businessmen know that arbitration is not an expensive method. It's just you have to invest in one go as opposed to the next 20 years of running back and forth from the courts. And of course, it definitely helps with attraction of FDI. If I'm not mistaken, both the barristers have spoken about the Singapore mediation. I think that we should definitely follow that way. And Singapore, it is, I believe, if I'm not mistaken, is the UN treaty. It's one of those UN treaties we can talk about. and this will actually help us because foreigners actually prefer amicable methods of dispute resolution to support international trade. And I personally know I was fairly young when my father spent so much of his time back in Singapore with shipping disputes and all. He spent hundreds and thousands of dollars for arbitration. So I knew what arbitration was from a very young age. I didn't know the in-depth details of it. But yes, of course, it's now here in Bangladesh. And I must say, because of the confidentiality, we cannot say how much money was total settled in the arbitrations provided by BIAC. But I must say that it is a huge amount. And out of the entire number of cases that we have mentioned to you, over 30 cases have actually been settled. They have come to settlement, and one of them included a government, and it was Bangladesh government and our foreign counterpart, and the figure was in the region of hundreds of millions. So that is also a plus point for us, and the fact that we have settled these kind of disputes in less than 388 days, as opposed to 7 to 10 years that is much talked about regarding the cases settlement, is a bit of an issue. So I hope that not only trade bodies but the justice system, the law ministry will take more place more efforts to create the awareness and the emergence of ADR in Bangladesh. And another thing that Advocate our moderator mentioned to me, that regarding the partnership with BIAC, how is the partnership benefiting in the large scale? What we have started doing webinars. We have started doing training programs. What is arbitration? What is the avenues of addressing commercial dispute resolutions? And you know that we have over 4,000 plus MSMEs, micro, small, and medium entrepreneurs. So these people, we are trying to make them aware through we have a business institute called the DCCI Business Institute. We have training programs jointly with BIAC and various other local and international organizations where we see that we make sure that we disseminated the message of deal among all our valued members regarding the MOU we had with BIAC, and as well as I think that this is also to send the message across that this is an effective and a low-cost resort mechanism for the MSME members to resolve their business disputes. And the partnership indeed, I think that is helpful for the DCCI members, and it adds a new dimension to our members' relationships. Thank you.
Thank you so much for your wonderful demonstration. Hope this may help not only to let DCCI expand, but also to add overall benefits to our nation's growing business industry. Thank you once again. Now we move to our next guest panelist, Mr. Muhammad Arfan Ali, sir. Sir, considering both judicial aspects and business community concerns, Banki as a client proper justice pache from the implementation of ADR mechanism. And besides such, can you discuss how ADR is managing the risk of non-performing loans and how the implementation of ADR is saving banking industry and financial institutions from risk profiling, especially during this COVID situation?
Thank you. Honorable Chief Guest of today's program, Justice M Imman Ali, and a special guest, Justice Khurshid Sarkar, and paper presenter and my fellow panelists. Assalamu alaikum and very good afternoon. I'm not a legal expert, or I do not deal with the legality that much, but one experience I do have, I can narrate about that, about the ADR. Back in my early career stage, I was the manager of our principal office branch, and we had a case to settle at the court. And then after some days, we reached to a conclusion with the customer that we'll settle this matter out of the court. And the justice helped us by arranging a separate sitting with the customer, and then we resolved our claims apart from going more on the legal side. I mean, that was my first practical experience with code and referring to arbitration, that we can reach a conclusion without going for longer period in the court system, or I mean in Bangladesh especially, where as we learned from the paper, that the numbers of judges in the court level are not that sufficient, or timeliness of delivery of the just cases are not very favorable at this moment. Another point is, I read about something from Mahatma Gandhi's life, but back in his early days of career, when he first traveled to South Africa for a case, and he was invited by some Muslim business people, and there when he reached there, he basically resolved that through ADR and not going through the court. So these two cases just gave me immense experience in a sense that we can do, and we can do better things, and we can do, I mean, justice even outside the court if we do keep ourselves open for ADR. In our case, especially in banking, we face in a daily basis that the customers, they fail to repay as per terms and condition, or they do not pay, or something like this, or we also sometimes cannot realize the money, and etc. And then what happens in most cases, we go to the court, and the court takes its action, of course, but it takes more time. And when we come to a point that, well, there is something called time value of money, and then we believe that ADR can be a better alternative for this case or justice, because for the commercial terms, it is my personal opinion that in commercial terms, if we can incorporate, as the paper presenter also suggested, and other comments are there, that if we can include the ADR rules within the contract, or within the framework of our understanding between two parties, we can do better, get the help from alternate resolution. Like in our case, in Bank Asia, we settled cases around 191 cases with 547 crore taka value outside the court, and we just implemented all those with the customers, and this helped us in reducing our loan losses, as well as reducing the our loan ratio, non-performing loan ratio. So from this particular area, especially money loan code, when we go to the code for remedy, before that we can apply the ADR and get the result, reducing the cost and time, because for the bankers, it is not our job just to move to the court and go there for years after years. And personally, I believe that the ADR rules, if applied to these banking transactions, can reduce the much more the NPL, because this can be settled earlier, and we can come to a conclusion and that can help the banking system even to reduce the loan losses. And especially, I have to mention here, because the statistics in the market and the tremendous pressure we feel as a banker because of non-performing loan, because of the justice system, I mean, with piled up cases, we cannot get the timely delivery of the, verdicts or timely delivery of the cases disposed of. So years after years, this is piling up. These cases, whatever we call that 10% or 20% of our NPLs in the country level, it doesn't give a good indication to the outside world as well. As we are talking about creating a good environment for the investors, outside investors, as well as inside investors, we need to have a better picture in terms of our performance in, banking system and bankers especially. Of course, I must admit that what we learned from the past, that we made mistakes, no doubt that we made mistakes in different form in assessing the customer risk or assessing the market or prospect or legal documentation, whatever. But the point is, when we call business, we need to keep it in a better shape so the economy can thrive and people, the entrepreneurs, can get the best of it. Because in our case, say for example, there are some practical things we see that when the customer failed to pay, they just go to the court and stop payment, just stay order. I do not find any reason why stay order, because it is, of course, a human right for a particular customer, but the money is stuck up by this process and the accounting mispresentation by this. Because when it is stay order, we do not show it in the classified position. That creates another problem because there is a mismatch and the customer is going and doing business once again. The stay order case is not a good idea for us, especially for the country as a whole, because these stay order cases are creating the environment where good customers are suffering. I mean the investors who demands better pricing, better treatment from the bank, they are not getting it. So it is very important matter, subject matter, when we call that ADR can be incorporated, rules can be incorporated in the contracts or in lending forms or in other, when we can make it, applicable for the general customer, the benefit will reach to these people. The entrepreneurs, there are two entrepreneurs, luminaries like Faruque Hassan and Rizwan Rahman. You see, they will be getting better price. They'll be getting better terms and conditions from the banks. So we believe that the topic today is very important, and I'm happy because the discussion is taking place with judges, judges present and Appellate Division judge and Supreme Court judge, and bankers and lawyers and other business people. So this is the way we can thrive and we can do better. And I would thank Lawyers and Jurists Foundation for this invitation. Thank you.
Thank you so much, sir. This notion of yours not only going to help outline the issue more in depth, but also it will help to improve ideas and methods relating to alternative dispute resolution. Thank you so much once again. Now we have our next guest panelist, Mr. Faruque Hassan, sir. Sir, we are all aware of this fact that the ready-made garment sector of our country is globally highly recommendable. বাট এই কোভিড প্যান্ডেমিক ক্রাইসিসে এডিআর কিভাবে আরএমজি সম্পর্কিত অভিযোগগুলো নিষ্পত্তি করতে সহায়তা করে এবং ফর দ্য প্রফিটস অফ দি বিজনেস কমিউনিটি অ্যাট লার্জ হাউ এডিআর মেকানিজম makes it cost effective, less time consuming, and get justice speedily. এই আলোকে যদি একটু আলোচনা করতেন।
Thank you, Advocate Asma. Honorable Chief Guest, Honorable Special Guest, fellow panelists, very good afternoon. BGMEA has been doing arbitration since 1984, but BGMEA has never had an institutional rules or procedural strategy for conducting arbitration. But from 2016, we made legally compatible with national and international laws, and an institutional set of rules have adopted under Arbitration Act 2001 of Bangladesh. Consequently, the advisor of BGMEA drafted BGMEA arbitration rules in 2016, for which Arbitration Act 2001 of Bangladesh, UNCITRAL Model Law on Arbitration, American Arbitration Association rules, World Intellectual Property Organization arbitration rules, and Financial Industry Regulatory Authority USA arbitration rules have been considered. BGMEA has its own arbitration committee who manage the administration of BGMEA Arbitration Center. BGMEA has also formed a strong panel of arbitrators from which parties choose their arbitrator. The member file their grievance relating to RMG export business, and every month BGMEA resolve a high number of disputes. Since 2016, BGMEA is doing arbitration under the said BGMEA arbitration rules 2016, and now BGMEA arbitration award is internationally and nationally accepted. BGMEA Arbitration Center provides binding arbitration awards, and where in court a party needs to spend huge amount of money and time, BGMEA is providing award at the lowest possible cost and within 3 months. BGMEA does both trade arbitration relating to export of RMG goods, and international buyers, factory owners, and workers all are benefited by this fast-track procedure. BGMEA arbitration is very effective, and most of the awards are compiled with being low at cost, and quick disposal of complaint help BGMEA to achieve higher rate of success. BGMEA is not a client but a provider arbitration. However, as discussed earlier, definitely arbitration and other ADR mechanisms are more cost effective and time saving, not time consuming. Thank you.
Thank you so much, sir, for your suggestions, and discussion will make a greater impact to our country's business community to grow more at large. Now, before we proceed further to our next guest, I would like to read a wonderful observation and comment made by our Honorable Justice Rifat Ahmed, sir, the Honorable Judge of the High Court Division of Supreme Court of Bangladesh. That is, I'm reminded of my own judgment in Muhammad Firdaus Khan Alamgir and others versus Judge Arfan Ali and others relating to 7 cases analogously heard and decided upon, reported in 34 BLD 2014, 341 and 22 BLT 2014, 317, extensively interpreting the mediation provisions of Section 22, read with Section 23 and 24 of the Arfan Ali Ain 2003 as amended in 2010. Significantly, the judgment highlights the need for a mandatory invocation of the Section 22 mediation process under this scheme of the art. It's a wonderful thing that Sir has made, the Honorable Justice has made a wonderful participation in our today's discussion through his commendable observation. Thank you, Honorable Justice Rifat Ahmed, sir, for participating in this manner. Thank you once again. And now we move to our special guest of today's event, Honorable Justice M Khurshid Alam Sarkar, sir. Sir, we are very grateful to have you here amongst us today. Sir, from your rich judicial experience, and as we those who belongs to legal fraternity are aware of this fact, that you, as a presiding honorable judge of the High Court Division Bench, served many orders of commercial disputes. So, Honorable Justice, sir, in the light of judicial perspectives, if you discuss about ADR and how it's enhancing judicial system.
Thank you, Asma. Honorable Chief Guest, His Lordship Justice Imman Ali, the Honorable Judge of the Appellate Division, the distinguished speakers, the keynote presenter, and the viewers across the globe. At the very outset, I would like to thank the organizers of today's program for arranging such an event. In fact, for the last few years, the general litigants, the business communities, and the law practitioners have been discussing about this ADR, that is Alternative Dispute Resolution, that the provisions which are in existence should be updated, should be amended. As has been presented by the keynote speaker, that there are provisions in our number of laws, number of statutes about the mediation, about the alternative dispute resolution. Alternative dispute resolution means and includes not only the arbitration, it also means and includes mediation, reconciliation, and arbitration. From today's discussion of the panelists, I understand that they are mainly focusing on arbitration because understandably here we are discussing the issues, commercial disputes. To entrepreneurs and one banker is here. So they are highlighting this commercial disputes. The disputes which are arising out of contract. But there are number of disputes Sorry, I got disconnected. Probably I was continuing, but the viewers were not listening probably. So what I was telling is that the main obstacle for speedy and quick disposal of cases, from my experience, I can see is the procedural law. It may be with regard to Arthurian case, it may be with regard to the NI Act cases, that is check cases with checks. But today, the speakers mainly focused on arbitration, that is arising out of commercial dispute. When there is a contract between the businessman, between two parties, and if there is a provision in the contract, then you can approach the court for formation of a tribunal, or on your own you can constitute a tribunal. But the number of dispute arising out of a contract is very insignificant in comparison with other commercial disputes, like the dispute with a bank customer with its banker, the dispute with a business person with other business person keeping the check as a guarantee. If I'm not mistaken, I have taken information from Dhaka court that there are as many as 64,000 cases pending regarding checks, that is under Negotiable Instrument Act. So if the business leaders who are present today in this digital dialogue, that is the president of BGMEA and the president of Dhaka Chambers of Commerce Industry, and also Mr. Arfan Ali, who is a prominent banker, if they take an initiative to approach the legislature that there should be a provision in the Negotiable Instrument Act to make it compoundable. You see, in India, they have updated this law long ago. So if you take an initiative to incorporate this provision in NI Act, then the judiciary will be benefited a lot. 64,000 only in Dhaka court. There are 64 districts in this country. So imagine nearly 20 lakhs cases regarding checks are pending in judiciary. So how you are going to reduce the burden of the judiciary? If you increase judges number 100 times, then the judiciary will not be able to reduce its backlog. So I would hope on one issue. The issue is Negotiable Instrument Act. The bankers are also filing cases under Negotiable Instrument Act. So if you make this compoundable, the courts can take an initiative trial court, but the higher courts as well. I'm giving you the number of cases only of the trial courts. Then whenever any party is aggrieved by the order of the trial court, they approach the high court, then appellate division. So again, the provisions which have been incorporated in the Arthurian Adalat Ain, that is section 2225, it has in fact made a sort of cumbersome provisions, the rigid provision. The judge should be vested with some discretionary power, more discretionary power to deal with the situations. To this end, I would refer the law of India. The name of the law is the Legal Service Authority Act 1987. By that law, the Indian legislature have given power to the judges that they can directly intervene with the dispute. Whenever a case is filed, that may be a case with regard to authoring or with regard to NI Act or with regard to normal contract, and thereafter, whenever the other party appears before the court, the judge takes a position that I will ask both the parties to mediate or to resolve it amicably. So by that act, the judge has been given a power to directly intervene in the matter. That is by ignoring the system of adversarial system. Our judiciary, not only our judiciary, most of the judiciary of the subcontinent are conducting their cases on the basis of adversarial system. Although there is no mentioning in any law of this expression, adversarial system, but the procedural law makes us adversarial system. So I would ask this the leaders of this business community to approach the legislature to enact these types of law by which the judge can directly intervene into these disputes. So it's a vast topics. Alternative dispute resolution means not only arbitration, mediation, and reconciliation as well. So it would take a long time. I think I'm running out of time. So I would only hope that the competent business leaders and the bankers will approach the legislature, at least with regard to the NI Act, so that a provision, a single provision with regard to compoundability, that whenever any case is pending before any court, that is the NI Act court, the court which is dealing with the cases of NI Act, it may be made compoundable. With this expectation, thank you all, and I would expect that there will be a positive outcome from this digital dialogue. Thank you all.
Thank you to our special guest, Honorable Justice Khurshid Alam Sarkar, sir, for embellishing the discussion and enlightening us with depth knowledge of arbitration. And now, at last but not the least, now we have our chief guest of today's event, Honorable Justice M Imman Ali, sir. Sir, we are very much glad to have you amongst us today. Sir, from your prodigious judicial experience that enriched the judicial system of our country, and being the active member of different committees for law reforms, in the light of this judicial experiences, Honorable Justice, sir, we would like to know your closing remark based on today's overall dialogue, the ADR from judicial aspects, how it's ensuring access to justice, and its overall impact in our country.
Thank you very much, Advocate Asma. First of all, I must say I'm very grateful for the organizers for inviting me to this occasion. It's a very timely dialogue, I believe. Something that is at the moment very close to my heart, as Dr. Khaled Chowdhury has mentioned. We are now in the process of trying to make people aware of the mediation scheme that our law provides, and that very many people are not aware of, or at least are not utilizing the provisions which are already existing in our legal system. I'd just like to, I must say very outset, being the last speaker, everything that I wanted to say has already been stated, particularly said by Dr. Khaled Chowdhury and my colleague, Justice Khurshid Sarkar. I still have to say a few more things, particularly with regard to my experience with arbitration and mediation. As already has been said, arbitration and mediation are not the only two ways of alternative dispute resolution. There are other resolution methods, including conciliation, negotiation, early evaluation, etc. But we are talking mainly about arbitration and mediation because those are the two that we are familiar with in our country. Negotiation doesn't very often happen simply because when people are at loggerheads, they don't want to negotiate, they don't want to talk, they want to fight. Conciliation, again, somebody else tries to reconcile the fighting litigants. It works only if the parties are willing to go ahead with it. Arbitration, similarly, arbitration is good. Is good, particularly if the parties are sincere in resolving their dispute. Now, unfortunately, we have found in very many cases that the people who come, the parties who come to arbitration, at least one is at an advantage, sitting on money, particularly huge sums of money, and very often we find that they use delaying tactics. My experience with arbitration, unfortunately, is not so good. I have dealt with many arbitrations as a lawyer, as the lawyer for TCB. I was involved in very many arbitrations. Sadly, I have to say that in many cases, the arbitrations took so long that it was hardly worth it. I remember there was one arbitration case that I had inherited. It started in the year 1966. And I finished it in the year 1996. And by that time, the company that I won the case against had gone bankrupt and there was nothing to gain apart from winning the case. So that is arbitration. Arbitration has many unfortunate hurdles where parties take the case to court in the midst of arbitration. And as a result, we have very often seen that arbitration, simple procedural matters are taken even up to the appellate division. And years go by and money is lost through the arbitration process. And at the end of the day, sometimes we even have to set aside arbitration awards because of the fact that there was some defect of procedure. I remember, I think only last month, after 17 years of a case being dealt with under arbitration law, we had to set aside the arbitration award simply because it was from the very initiation, the whole thing was illegal. That was what we declared. So unfortunately, I have to say that I have my reservations about arbitration now, although it is certainly a good method of dispute resolution, but only if both parties are sincere and they do not pick little procedural incidents and take it up to the highest court, and as a result, the whole thing is delayed by many, many years. Now, ADR generally is, of course, the best method of dealing with disputes. As you are all aware, everybody knows, I think across the globe, it's a whole phenomenon that the law takes a long time to process. And we are dealing with cases in our system which started 50 years ago, civil cases particularly. So let us go back to the year 2000. That is the time I think we began to realize that the backlog of cases that we have is so unmanageable that we have to think of other alternative ways. That is in the case of our country. Now, I remember reading somewhere, I think Justice Rizwan Rahman, when he became Chief Justice, he mentioned how Abraham Lincoln had, in a lecture to the lawyers, told them to discourage litigation, discourage court cases. And I've just got a little bit of quotation from that speech, if I can just read it out to you. আজ থেকে 140 বছর ও আগে আব্রাহাম লিঙ্কন বারের সদস্যদের উদ্দেশ্যে তার পরামর্শে বলে গেছেন, মামলা মোকদ্দমা নিরুৎসাহিত করুন, যখনই সম্ভব হয় আপনার প্রতিবেশীদের আপোষ নিষ্পত্তির ব্যাপারে উদ্বুদ্ধ করুন। মামলায় সাধারণভাবে জিতলেও সময়ের অপচয়ের দিক থেকে কেউ প্রকৃতপক্ষে কিভাবে ক্ষতিগ্রস্ত হয় তা তুলে ধরুন। শান্তি প্রতিষ্ঠাকারী হিসাবে আইনজীবীদের ভালো মানুষ হওয়ার বিরাট সুযোগ রয়েছে। So a number of things come out of that small sentence, and that is one, even if the party, even if a litigant wins his case, he has not won. Let us be practical. He will take the case for appeal, then he will take the case for revision, then he will take the case for further appeal before the appellate division, and then the review, and then finally somebody may win and somebody will lose. The winner will go happy, the loser will cry. Now, that in the process will cost both parties a lot of money and also time as well. And as Mr. Rizwan Rahman said, he'd rather pay quickly, even if it is a big sum of money, to save the time and save the cost in the longer run. And also, I think that was supported by Muhammad Arfan Ali, who said that time is a value money, that equation that has to be kept in mind. And subsequently, in the year 2003, other chief justices of our courts have said, of our country have said that, you know, the best method of dealing with cases in our scenario is ADR. Justice K.M. Hassan, when he became the Chief Justice, he said the dockets of the courts have increased exponentially. And as you have heard today, 4 million cases are pending in our courts. We cannot hope to get through them. We never will. Even if you appoint hundreds of judges more, you still will not get through the backlog of cases. The Justice Mainaruza Chowdhury mentioned how ADR mechanisms are necessity because of the huge backlog of cases. So I think it's an obvious thing now to go for ADR. But see, to have access to justice, because of the backlog of cases, there is a huge delay. And that effectively means that the litigant public is not having straightforward direct access to the justice system. And that, of course, is, does not help in establishing rule of law. So in the year 2003, as has already been mentioned, there was change. We had the amendment to the Code of Civil Procedure, Section 89A, 89B. 89A relates to mediation, 89B relates to arbitration. Now, even then, what happened? Nothing happened. Mediation did not take off. So as a result, we find that in the year 2012, mediation was made compulsory. So the law mandates that when the written statement is filed, the judge must send the case for mediation. I have to say that in spite of that, I don't think that mediation has become at all popular, and mainly because people, I believe, are unaware. Now, what I believe should be done, as you have heard from our Committee on Judicial Reforms, we have instigated the Supreme Court into sending a circular to all the judges of particularly the lower courts. Of course, it applies equally to judges of the high courts when they are hearing the matters on appeal, because Section 89C, you will find, makes it mandatory for the court to send the matter for mediation, even at the appeal stage. And you'll find in the Orthorin Adalat case, Section 22 goes for mediation. And strangely enough, you'll find that in the Arbitration Act also, there is provision for sending a case for mediation, even in the process of arbitration. So I believe, and I've been saying this now for some time, that mediation is possibly the best way to resolve disputes that we have right now. But the problem is that people are not aware and it is not being properly used. Now, the mediation has also been introduced in the Legal Aid Act. That gives two sides of mediation. One, mediation even before the initiation of any case. And then mediation can be referred to the legal aid officer from the court. So the legal aid officer has two functions: mediation before the case starts and mediation where it has been referred to him by the court. But the important thing is, and that I'm now in the process of getting someone to draft in fact, we've already drafted it. So you are getting advance notice of a guideline, which will be again sent to all the judges of the lower judiciary, as well as to the High Court, I hope, which will explain the benefits of mediation, because until and unless the parties are made aware of the benefits of any legal scheme and system, I think the scheme will not take off. I remember, possibly it was 2003 or 2004, I was in Cox's Bazar training some judges on some children's issues. And at that time, some colleagues of mine, Supreme Court judges, were training or trying to give lawyers training on ADR, arbitration. And from what I heard, part of that meeting, the lawyers were not accepting the scheme because they were under the impression that ADR will dispose of their cases so quickly that they will be out of pocket. The case will be gone in no time at all. So I was asked to say a few words, which I did. I simply said, look, if you can establish yourself as a lawyer who can dispose of cases quickly, then you have a good chance of becoming a better lawyer and getting even more cases, because people will know that coming to you will dispose of their case quickly, and more people will then come to you. I don't know whether it worked. I perhaps believe that it didn't work so well, but it is the lawyers who are feeling, I think, disgruntled because they believe that they will lose out on their cases. But funnily enough, when we started the awareness program on mediation, some junior lawyers came to me and said, sir, leave it to us. We will do it, because the client comes to us first. And it is only the senior lawyers who worry about their fees. If you look to us, we will make sure that people go for mediation. I hope they do that. But essentially what I believe the court must do is to explain to the litigant public what I have suggested in the guideline, is that there must be a date fixed for hearing and for disposal of the case or sending the case on mediation. Because otherwise it's very simple for the judge to say, the law says go and mediate, so go and mediate. If you can't mediate, come back. It's easy to say that, but that does not serve the purpose behind the law. What the judge must say is that the law allows for mediation. We have to send you to try to mediate. There is no compulsion to conclude the mediation. There's no compulsion to come to a decision through mediation. But there is a compulsion on the court to send you to mediation. And now I'm going to tell you the benefits of mediation. Now, the benefits are, you choose your own mediator. You have the choice that if you choose to have the case mediated by the court, by this court, or by the legal aid officer, then there is no cost involved. So you don't have to pay for the mediator. And then the cost of the mediation itself can be borne by the legal aid scheme, if you qualify for legal aid. And then other important factors that have to be brought to the knowledge of the litigant public is that the whole scheme of mediation is confidential, anything that you say in the mediation process, any documents that you produce in the mediation process, it will all be confidential. In other words, none of that will come back to the court. So you will not be prejudiced, or the judge will not be biased by what you have said in the mediation proceedings. Next, it is informal. So unlike the court or arbitration is supposed to be informal, but nevertheless it is still more akin to a court process. Mediation is nothing like court. It is totally informal. And here, the important thing is, unlike the court or arbitration, here the parties talk. The mediator simply is the middleman. He sits there, he controls the situation, he stops the people fighting, he's a referee. But he does not actually take part in the process of negotiation. He simply gets the parties to talk. Mediation is very speedy. Even arbitration can take a long time. I told you about a case which started in 1966 and ended in 1996. I told you about a case which came to us I think, couple of weeks ago. No, maybe last month, where the arbitration had taken the whole thing had taken about 17 years, and it all came to zero. So that can take time. Mediation, on the other hand, is very strictly time-bound. It has to be done within 60 days. And in addition, on application by parties, it can be extended for further 30 days. So 90 days is the maximum. And then if the parties come to an agreement, then the decree must be passed or order passed within 7 days of that. So you're talking about a total of 97 days, which means you're saving years and years of litigation, which means you're saving money for the lawyers that you would have to pay for attending every time the court case came up or every time the arbitration took place. And arbitration has become very expensive, as has already been said. Arbitration has now become very expensive. I'm sorry for my colleagues the retired colleagues particularly, who are now apparently earning lots of money doing arbitration. Maybe I'm acting my own feet by saying that arbitration is too expensive, and I think we should go for mediation instead. So mediation is less expensive. And on the other hand, mediation can also be funded from the legal aid fund. When the parties reach an agreement, that is final. It goes to the court, it becomes a decree and order of the court. And the most important thing is that if they reach an agreement, of course, the parties by law will get the fees, court fees, paid back to them, refunded. And as I was going to say, the years will be saved. Instead of going back all the way up to the appellate division. And most importantly, as I was saying, the mediation process leaves the parties in peace. Let me give you an example of a case where two parties who were in business together, one owed the other 35 lakhs. In the end, it turned out to be a Negotiable Instrument Act case. And of course, as you know, you go through the process of the law, and the person who issued the check which bounced is sent to jail. And he filed an appeal, he paid half the money. So 35 paid half is what, 17 and a half? And then 17 and a half still owing. It came as far as the appellate division. And by this time, the party who was the defaulter was agreeing to pay. But he couldn't pay the rest of the money in one lot. So he wanted time to pay. And I said, well, there's nothing for us to do. It's strictly a strict liability case. It's a criminal case. It is not compoundable. You go and talk to the other side. And if he agrees, it's fine with us. So we gave him the time. Now, that was the important thing. We were able to give him the time. And would you believe, when he spoke to his business colleague, they came back, and the complainant came to court And he said, sir, if he gives me another 10 lakhs, I'll call it quits. So he was willing to forego the court order to pay 17.5 lakhs. He said, give me 10 lakhs and we will say go. And then he came back and he said, he gave me 5 lakhs. That's enough. I don't need any more. I said, you will get that money. He said, it's more important that we are still on business terms because I can get that money from him through my business transactions. So that is the benefit of mediation. It mends relationship, it extends relationship, it keeps relationship going, it brings peace. And that's not just in commercial litigation, it's in all spheres of litigation. In the family litigation, it brings peace. Because the parties themselves have agreed, if you like, they have agreed to cut their losses. They've agreed to take less than they would otherwise. But you see, as Mr. Rizwan Rahman said, 10 lakhs today is better than 15 lakhs in 2 years' time. So these are the aspects that I think have to be now brought to the knowledge of the litigant public. And I will seek all your cooperation and help, I think, to get this done. Because let's face it, by mediation, you are forestalling or cutting across. Each mediation stops or at least reduces 45 cases in our legal system. If you work it out, a mediation on appeal, on revision, appellate division, review, and then think about all the other ancillary applications that come all the way up to the appellate division. Preliminary issues that come all the way up to the appellate division. Side issues, procedural issues that come all the way up to the appellate division. So I think on a conservative estimation, I work out that each mediation gone through positively and concluded will save us from 45 other cases that could potentially come all the way up to the appellate division. So even the cases that are pending now can be resolved through mediation because there is no time when mediation has to start. Yes, it has to start after filing of written statement, but it can be done at any time. We've done it in the appellate division. I've sent many cases for mediation. Not that law permits me to do that, but we have done it for the sake of justice. But the law mandates the trial court and the appellate court to send cases for mediation. And I believe this way we will deal with our litigant public better. They will get justice quicker and certainly less expensively. So I've spoken, I think, enough. Thank you all very much for your patient hearing. And I thank the organizers for inviting me to say these few words. And I hope you will accept what I have said. I hope you will help us to promote mediation and other alternative dispute resolution. Certainly, all dispute alternative resolutions are better than litigation. Thank you all.
Thank you so much to our chief guest of today's event, Honorable Justice Imman Ali, sir, for sharing the wonderful remark and adding much vibrancy to today's discussion. That tremendously helped us to attain full knowledge, especially in relating to mediation and arbitration. We are at the last segment of our today's discussion. As we are aware of it, that a dispute resolution outside of courts is not new in Bangladesh. Non-judicial and indigenous methods have been used by the societies for a very long time. Though there are no uniform ADR law in Bangladesh, but there are a lot of legislations which contain provisions relevant to the ADR process in Bangladesh. And there are some well-known ADR mechanisms in Bangladesh, such as mediation, negotiation, conciliation, arbitration, and so on. In the enlightenment of this discussion, we have piled up very relevant proposals and remarks made by our chief guest, special guest, keynote speaker, and guest panelists, which we are hoping may attempt to be implemented practically in near future. Thank you to our chief guest, special guest, keynote speaker, and the guest panelists, and all the viewers for your wonderful participations. Till then, take care, stay safe. Hope to see you all again with another discussion in the upcoming segment. Khuda Hafiz and Ramadan Mubarak.
Thank you.
Thank you. Allah Hafiz.
Allah.